Hi, Elizabeth. Nice to meet you.
Nice to meet you, Rebecca. How are you?
I'm well. How are you?
Doing okay. Lot going on.
I bet. So I have the deck up. Hopefully you can see it.
I can.
Is it best if I control it, or do one of you guys want to take control?
Um, Sarah, I think, is going to be doing the majority of the presentation, so it might be easiest for her to have control,
Yeah,
but
absolutely. You let me
um,
know.
mhm. She'd speak to that better than I would, but I would assume
Okay,
she'd be that best person.
excellent.
Yeah.
I think I gave everyone the opportunity, but we'll see if that works.
Okay, if we can all do it, that's even better because we're going to be splitting
Um,
it up.
for now, can you see it moving?
Yes.
Okay, excellent. And you can see the presentation view, presenter view?
Yes, I can.
Great. Like with your notes.
Oh, let's see. Hang on. To grid view. Oh, let's not do it that way. I cannot
So
see it with the notes,
you
but
should have an option, the co-presenter.
I am awful with this kind of stuff, so hang on. English grid view, slides. Action. Take control. Should I take control?
I think you can take control.
Okay. Okay. Um,
Can you see your notes now?
no, honestly, I don't personally need them, so
Okay. Okay. Great.
it's fine. Hi,
Hi,
Marjorie.
Marjorie. Hi, Sarah.
Hi,
Marjorie, I
everyone.
don't think we've met. I'm Rebecca. I oversee the US Pro Bono program here at Freshfields.
Oh, we haven't. Hi, I'm Marjorie, obviously. Thanks.
Great to meet you.
Same.
So Elizabeth and I were just discussing the presentation. I'm here if you need me, but I think that if you guys see that controls button right on the top,
Um,
you can take control when you want to and run the deck yourselves.
okay, awesome.
How do we
I'm gonna
do this?
stop taking control, and then
I was
Marjorie,
just gonna say,
since
well,
yeah,
I
and
was gonna
then
say, why doesn't Sarah take control and just be in control of the whole thing and then forward? Does that make sense?
oop, what did I do?
I can reshare it. No
Okay.
worries. Do you see it again?
Yes.
So who's gonna take control of it then?
Sarah, are you speaking?
Yes.
Okay,
Just
now I
let
can
me
hear you.
know when we should start, Rebecca.
Yeah, absolutely. I thought I would just give a couple minutes
Yeah,
for
yeah.
folks to join, and then I'll do a quick introduction, and then we'll get going. Maybe in 2 minutes.
Sounds good.
So Sarah, you're gonna take control and then go through the slides?
Yeah, I'm happy to do that.
Yeah, I think that makes sense. Is
Yeah.
that okay with you, Elizabeth?
All right, I've lost control, so I think you did it successfully, Sarah.
Yeah. I see the navigation and all of that. The
Excellent.
arrows.
And for everyone on the line, I just shared the most recent deck this morning. So if you want to follow along on the screen, that's great. If you want to follow along on your personal computer, that's also great. Good morning, Danielle and Renee. It looks like we're still waiting for a few folks from Bridgewater. Is that right?
I think that's right. I know a couple of people are going to rely on the recording. So if you want to get started, we can also have them catch up with the tape.
Well, they'll only miss my very important intro at the outset. So I just wanted to welcome everyone. I know there's some repeat clinic attendees here from both Bridgewater and Freshfields, and a lot of new faces as well, which is really exciting. I'm Rebecca. I oversee the U.S. Pro Bono program at Freshfields. I think this is our third collaboration with Bridgewater, which is really exciting. And we're also working, most importantly, with Sanctuary for Families. Sarah, Elizabeth, and Marjorie will be giving us a about 2-hour, I believe, training today on special immigrant juvenile status. I don't want to over-explain or get it wrong, but from my conversations with the folks over at Sanctuary, I think Sanctuary has been working really hard to figure out how to help people that are struggling in the U.S. with immigration relief. This is the first time that they're doing a SIJS clinic, I believe. So really exciting that we're piloting the program with them. I've done some SIJS cases myself. I'm really excited for everyone here to get involved and meet clients in a couple of weeks. And Sarah, Elizabeth, and Marjorie, do you want people to hold their questions, ask as things go on? What's best for you?
We did allocate some time at the end for questions, but also I believe there should be a chat. Feel free to put things in the chat as well.
Fantastic.
Yeah.
I will give you all a CLE code about halfway through. And then Freshfields needs me to tell you that we are recording this. There is a transcript and a recording, and I can share that with anybody who needs after the session. If anyone has any questions, feel free to message me on the side or message me in the group chat, and I will hand it over to Sarah, Elizabeth, and Marjorie.
Thank you, Rebecca. Good morning, everyone. Thank you for joining us, and thank you for signing up for the SIJS clinic, which will be on October 21st. My name is Sarah Sayed. I'm an attorney in Sanctuary for Families Immigration Intervention Project. Today with me, I have Marjorie and Elizabeth as well. I'll let you both introduce yourself. Elizabeth, you can go ahead and start.
Okay. Hi, everyone. I'm Elizabeth Wood. I'm a senior staff attorney with the Immigration Intervention Project at Sanctuary for Families, and I work out of the Brooklyn Family Justice Center.
And I'm Marjorie Deibler, also a Sanctuary for Families staff attorney. I work out of the Manhattan.
All right.
Marjorie, I don't know if it's just me, but your sound is a little bit muted, at least on my end.
Okay.
It's a little low, yeah.
I don't know if a different microphone is picking up or something.
Is this any better?
It's still a bit low.
How about now?
Still a bit low. I can hear it. Just I'm turning the volume up.
Okay. Sorry. Yeah. Okay. I'll see what I can do.
Yeah.
Thanks.
Excellent.
I'll just go ahead and get started though. Let me go to the next slide. So the October 21st clinic will be, as Rebecca was saying, a SIJS clinic. So today's presentation, we're going to first go over what is SIJS, what is special immigrant juvenile status. Secondly, we'll be going over the federal law and regulations, then the overview of the overall SIJS process, which is, as you'll hear later on, it's a threefold process. The first one being in family court, and that's the one that you'll be focusing on within the clinic. Second will be with USCIS filing what is called an I-360 form, and then down the line filing an I-485 or colloquially a green card application, which is really the end goal of a SIJS case. Then we'll be going over some recent updates and how SIJS has changed in the last few months with this new administration. And then lastly, we'll be going over some tips for trauma-informed client interviewing. And I will turn this over to you, Marjorie. Oh, you're muted.
Can people hear me now? Any better?
I would say it's the same. I can hear you, but it's a bit low.
Okay. I'm going to speak up and hopefully, how about now? Is that any better?
That's perfect.
Okay, I'll speak up. So what SIJ is, it stands for Special Immigrant Juvenile Status. What that means, the definition is here, but it's for an immigration form of relief, and it's available to children or youth, anybody under the age of 21. They have to have been declared dependent by a juvenile court, which we're going to explain, and where reunification with one or both of their parents is not viable due to abuse, abandonment, neglect, or other similar basis under state law. In New York, under state law, a similar basis is if one or both of the parents are deceased. What the goal of it is really just to protect these youth or children, and it really gives them a pathway towards citizenship. What a SIJ order does is it makes the child eligible to apply for permanent residency, which ultimately will allow them benefits of financial aid and public benefits. They can work lawfully in the U.S., eventually gain citizenship, and provide stability for the family, including access to public benefits. Advance the slide. There are some issues with it, however. The child is not eligible to assist either parent in applying for their immigration status. So a lot of times you find out what we see is when children could become a U.S. citizen, they can then apply for their parents. That's actually not possible with SIJ. And that's something that's very important that needs to be explained to the child or youth when they're applying for SIJ, because it's not a pathway for the parent. Similarly, that they have to wait for naturalization when they become U.S. citizens in order to petition for any of their siblings. So the SIJ statute, and we've listed here INI 101 A27J. What it says is that the juvenile is dependent under juvenile court, or the juvenile court has committed or placed that juvenile into custody of an agency or department of the state, or to an entity or individual appointed by the state or juvenile court. What we talked about before, and in New York, this is really family court. Reunification, we talked about one or both parents is not viable due to abuse, neglect, abandonment, or a similar basis. And it's not in their best interest to return to his or her own country of residence or the parent's country of residence. DHS must consent to grant SIJ in these instances. So it's somewhat of a long process. What we'll do for the SIJ day that we're going to have on October 21st is really the phase 1 preparation. So phase 1 is the state juvenile court and dependency and special findings. We're going to go into that in a bit more depth, but basically just an overview. They have to go through New York Family Court and issue a dependency, in other words, appointing a guardian, special findings. That information, when it's done, is then sent to phase 2, which is SIJS, and a SIJ, which is an I-360 petition application is submitted. Then that goes off to SIJS. There's now a fee with that, and then you get to phase 3, where they would write back. SIJS would basically say that phase 2, they approve it, and then phase 3 is adjustment of status, where they become an LPR. So the family court, I mentioned family court. Juvenile court means a court is located in the U.S., has jurisdiction under state law to make judicial determinations about custody and care of juveniles. Each state is different, and each state has different regulations. So what we're really focusing on is New York. In New York, juvenile court can commit the child to the care of the state, child welfare authorities, or an individual or an entity. Mostly, again, what happens with us in New York is family court. It also could be surrogate or the Supreme Court. Various types of state court proceedings. There's neglect, juvenile delinquency, adoption, PINS, guardianship, or custody. What we tend to do with SIJ is guardianship, most often guardianship, occasionally conservatorship, but it's a legal authority to make decisions for the child, often for non-parent, but here it doesn't need to be, it can be for one parent. Custody is one parent versus the other for sole custody, and that's available for SIJS findings dependent on state law. Again, in New York it is available. Child protective dependency proceedings, and it could be for neglect or abuse filed by state services or authorities, and then adoption where non-parent becomes the child's parent. The guardianship procedure. Now this is really what is most applicable here for SIJS. So Article 6 of the FCA, and again, Article 17 of the SCPA, basically says that guardians can be appointed to a child less than 21 years old. If the child is over 18, they have to consent to the appointment of a guardian. Any adult person can be appointed as the child's guardian as long as the appointment of the guardian promotes the child's best interest. I just want to talk about that. It doesn't have to be, when you think of adult, you think of somebody who is, decades older. It doesn't have to be. I mean, I've had such cases where the applicant was 20 and the guardian was 23 or 24. We'll talk about what has to happen. I'm going to skip over for a second. So the guardians who are appointed, they make the decisions regarding education, medical care, which will promote the child's physical and emotional well-being. It can be, what you have to show is that there's some sort of bond, there's a relationship between the child and the guardian. Examples is that the guardian can help the child with decisions about schooling, with medical care. It doesn't have to be, they don't have to have financial, they don't have to pay for the child or offer any financial assistance. When applying for guardianship, they need to be cleared by OCFS. And what that means is that the guardian has to put down a lot of information, including their past 28 years of their addresses. Very specific in the form, and we might get into this, but for example, if they say 28 years, if somebody lived at one location from January through March and then moved in April, they'll send it back to you. That has to be January through March and then March through whatever other month. So it has to be very specific with the month and the year. They also have to be, they may need to be fingerprinted. Depends on the borough, each is a little different. Also depends on the judge who's making the decision, but if possible, best to get the potential guardian fingerprinted. So documents to file, lots of documents. They're very simple, but there are a lot of them. This is Form 6.1 or 6.1a. 6.1 is for guardianship petition, or the 6.1a is the self-petition for the guardianship. Again, it depends on the child's age. 6.2 is an oath and designation of service of process. 6.3 is the consent of guardianship if the child is over 18, or the preference if the child is over 14 regarding the appointment. The Central State Registry form, that's the one I was just describing, has to include just history of everyone in the household over the age of 18. Again, that's can be somewhat of a problem. Not a problem in the sense that it's difficult. It's just to get everybody to fill the information in. That requires a lot of sort of pursuing, especially if there are other people, adults 18 or over in the household. Copy of the child's birth certificate has to have a certified translation if applicable. And Form 6.4, that's the consent of a parent. So for instance, a lot of the clients we're seeing are youth that have come on their own, and they might have been abandoned by one parent. So in that case, or the one parent has died, and the remaining parent maybe lives in their home country. If that's the case, the best thing, if possible, is to get them to sign this 6-4, where the parent consents to the guardianship. And the benefit of that is that you don't have to then serve the parent all the documents. Outside of New York, if they are outside of New York, you might have to do personal service. Again, if you get them to sign the 6-4, that's better. And you might have to serve the parent, the other parent. You can get a waiver of service abandonment. So if there's no service necessary to parent or parents who have abandoned the infant or the child, challenging. So it depended on the judge. We were in a situation where there was abuse, and yet this particular judge still demanded that we provide service to the country, to the parent in this case it was in Africa. So again, waiver of service is better, and better to do a motion to waive service. The consent of the parent, and that is any person who has a right to administration prior or equal to the waiver of the petitioner can renounce his right and waive the issuance and service of process by an acknowledged instrument. And that was that 6-4 that we were talking about. Reminder, it has to be notarized in the place where it's signed. There's a little bit of a, it doesn't always have to be, and that's something that you might want to just talk to the person, whoever's helping you with it. We've had instances where we have not had them notarized because, again, the remaining parent lives in a rural area of Africa and notarization is not possible. But then what they can do is to sign their specific wording, which says that they would be subject to the laws of in New York if you are lying. Seems to be working. We also have to have certified translations of the affidavit as well.
Okay, thank you, Marjorie. So now we're going to talk about the motion for special findings. You'll see here at the bottom, we have a list of everything that goes into a motion for special findings. In green highlighted, or in green, you'll see notice of motion, affidavit from the petitioner or proposed guardian, and the affidavit from the young person. Those are 3 documents that you all will be drafting on the day of the clinic on October 21st. So once a custody or guardianship petition has been filed, and you'll remember that Marjorie went over the different ways that one can show a child's or a young person's dependency on the court. One of them is custody and another is guardianship, though for the purpose of this clinic, we'll be focusing on guardianship. So once that petition has been filed, or even as you're preparing that petition, you can also prepare the motion for special findings and file it jointly with the guardianship petition. So the overall motion should include, like I said, the notice of motion, an affidavit of service, or as Marjorie was saying in the last slide, you could do a motion to waive service, a proposed special findings order for the judge, a memo of law as well, affidavit from the proposed guardian, affidavit from the young person, and other relevant information to support the motion, which could be birth certificate, which of course has to be translated if it's not in English, maybe even a letter from the young person's counselor at school, a country condition report. A lot of judges also want to see pictures of the home. If the young person will be living with the guardian, they want to see exactly what the home looks like, sometimes even a picture of the inside of the fridge or the bathroom. So there's a lot of components that go into the motion. And of course, the ultimate goal of that motion is to obtain a special findings order. That order must make the following findings, and we're going to constantly be going over these 5 elements, and the first being that the minor is under 21, that they are unmarried, that they have been declared dependent on a juvenile court or committed to custody of state agency or another individual or an entity that was appointed by a juvenile court. And you'll see here that the statute says juvenile court. For the purpose of New York, this is family court. Number 4, the special findings order must show that reunification, that the young person's reunification with one or both parents is not viable due to either abuse, neglect, or abandonment. And there is a 4th option there, that any similarly situated basis under state law, and we'll go over that later. The 5th element that has to be shown in a special findings order is that it is not in the minor's best interest to return to their home country. And the special findings order is arguably probably the most important part of the family court process in a SIJS case, because that is what gets sent over to USCIS and is really the basis for why the person is requesting SIJS status. So when we look specifically at the age and marital status of the subject child or the young person, we need proof that the young person is less than 21 years of age, which can be established through a birth certificate with a translation if needed, and their own testimony. And alongside the testimony is that it would go in the young person's affidavit, and they would testify to whatever is in their affidavit when they appear before the family court judge. You may also be able to use a passport in some instances to show the date of birth of the young person, especially if they do not have a birth certificate. And then proof that they are unmarried can be established through testimony and through their affidavit as well. And again, you know, this we've stated this a few times, and we're probably going to keep reminding you all that a big part of a special findings motion is showing the judge that the young person's reunification with one or both parents is not viable due to either abuse, neglect, abandonment, or a similar basis under state law. So the other element is the non-viability of reunification with the parents based on abuse. So that's the first prong within that element. So the abused child, abuse is present when a parent or person who's legally responsible inflicts or allows or creates a substantial risk of physical injury that causes a substantial risk of death, disfigurement, protracted impairment of the young person's physical or emotional health. Abuse is also present when the parent or both, one parent or both, allows certain offenses to be committed against the child. So some, of course, examples of abuse are burns, fractures, maybe firing a gun in the proximity of the child or young person, repeatedly hitting them on the head, beating them with a belt, or delaying medical treatment for injury. And these are all facts that you're going to have to be talking to your client about on the day of the clinic. And of course, you know, this can be very heavy, very sensitive topic and re-traumatizing for our clients. So we will be also going over some tips and strategies to navigate these conversations with clients. So some case examples of abuse being present in the young person's life and in their case would be that maybe the petitioner's medical experts declared that the rib fractures suffered by the child had been inflicted intentionally, and the record reflects that the child was in the parents' care when they suffered the fractures, or maybe even the father failed to provide reasonable and adequate explanation for the child's injuries. So if the child has medical records showing that they had a fracture and maybe the healthcare provider who was treating them suspected abuse, and that's in the medical records, that's something important to add with the motion. You know, I will be speaking to all of the clients before the day of the clinic and asking them what evidence they have, if they've been to the hospital. So if they have any of this evidence, we will make sure that it is in your packet on the day of the clinic. Though you may have to ask the client more information about those records. More often than not, most clients do not have medical records, especially if they're a young person. They often did not have the ability to really advocate for themselves before doctors or even take themselves to the doctors. So mainly it will be through their testimony and what they inform you and what you write in the affidavit, which is still a strong basis for a special findings motion. So the second prong within that element is showing neglect, that reunification with the parent is not possible due to neglect. And the New York Family Court Act defines neglect as a child's physical, mental, or emotional condition is impaired or is in an imminent danger or becoming impaired due to the parent's failure to exercise minimum degree of care. And some examples of neglect are the misuse of drugs or alcohol that result in harm, exposure to domestic violence, maybe even if the child was not physically harmed by the parents, the child witnessed one of the parents physically harming the other parent. And especially if that has happened frequently, it's really important to show that it was a pattern within the child or young person's affidavit. Maybe there was inadequate supervision, a failure to supply adequate education or medical care. Maybe the parents never took the child to school, or maybe even something I've seen before is having a young child, maybe as young as 6 or 7, drive on a motorcycle to go to the store to pick up some things that could fall under neglect as well. A failure to supply adequate food, shelter, or clothing, although they're able to do so. So it's one thing if the parents were in a place financially where they could not do that. If you are arguing neglect on the basis of failing to supply food or shelter, it is important to show that the parents did have access to that. And then excessive corporal punishment and abandonment. So a case example of neglect could be a dangerous request. Maybe if the father has demanded that the son get a knife, which then the father holds to the mother's neck in the presence of the child, or maybe the child and their sibling also witness this. This action creates an imminent danger of impairment to the child's emotional and mental condition. So that's just an example of a fact that could be included in the young person's affidavit to support an argument that neglect is a reason for why reunification should not happen. And then the third prong under the element of the non-viability of reunification is abandonment. So the New York Family Court Act addresses abandonment within its definition of neglect. So it states that a child is neglected if they are under the age of 18 and have been abandoned according to the criteria set forth in the social services law. Also, a child has been abandoned by their parent if such parent evinces an intent to forego their parental rights and obligations as manifested by their failure to visit the child or communicate with the child. And then another New York State law states that abandonment is to plan for the child where such steps may be necessary to provide an adequate, stable home and parental care. So if there is a lack of steps taken by the parents to provide adequate, stable home and parental care, that could fall under neglect as well. In the past, we've also argued that parental abandonment went beyond a failure to visit and communicate. So even if the parent was sometimes speaking with the child, or maybe if they called the child 2 weeks before the family court appearance, that does not create enough of a foundation of a relationship to forego the abandonment argument. And I had a case actually where a few weeks before the family court appearance, the father started calling the child. And even though for 14 years before that, he had only called her once. So let's go into a case example of abandonment. So a lack of support, financial or emotional, can show abandonment. If a 17-year-old child came into the country with their father while their mother stayed behind and the father kicked the child out of the house, leaving the child without a home or any resources, the child no longer knows of their father's whereabouts or contact information, and the father has not contacted the child in 3 years or provided any support. Of course, that would fall under abandonment. And I just want to point out that even though there are these different prongs within the element, you can technically argue all three of them, and then see which ones stick. Generally, abandonment or neglect we find that those are the best ones to, even abuse, but they're all fine to argue. It's just that with abuse, oftentimes family court judges require more testimony from the child, is what we've seen. And then the last prong is that there is a similar basis under state law that could be similar to either neglect, abandonment, or abuse. So New York family courts have routinely found that reunification with a parent is not viable due as a similar basis under state law for certain types of cases, such as if there is a death of one or both parents, if there was a voluntary placement statute, so which means that that if the parent requested for their child to be placed in foster care, or if something falls under the destitute child statute. And as we stated earlier, one example of this is when there is a death of one parent. So if a child if a guardian applied to be if the uncle applies to be the guardian of their nephew, whose father was deceased and whose mother abandoned them, that would be considered similar basis under state law. And Elizabeth, I'm going to turn this over to you now.
Okay, thank you. So on the day of the clinic, what everyone will be doing, what everyone will be doing is drafting the affidavits from the petitioner or proposed guardian, as well as from the young person. And so we're going to go over what those affidavits should contain. So the affidavit from the proposed guardian and from the young person as well often are kind of mirror images of each other. However, the proposed guardian's affidavit will more heavily focus on their relationship to the child and how they support that young person. Remember that the family court is really looking at what is in the best interest of the child, and from a very holistic perspective, it's a totality of the circumstances test when they're looking at this. And so you're trying to show how this person supports the child and why it would be in their best interest to be appointed their guardian through the affidavit. So some elements that the affidavit of the proposed guardian should really touch on, the first paragraph really should just be stating their identity, their date of birth, their age, and essentially who lives in the household with them, right? And in addition to their relationship to the young person that they are seeking to be appointed as their guardian. So again, you want to explain how the proposed guardian cares for and supports this young person. What the family court looks to most frequently are kind of three main elements, looking at the child's education, their housing, and any type of financial support, as well as medical care. So if you hit those three prongs, really, it will be helpful in the petition and supporting the petition. So when looking at those three elements, right, education, medical care, and housing or any type of financial support, things you can look at is who helped this individual enroll in school or enroll in any classes if they're attending school or attending any type of a class. How does this person support them in their goals and their educational pursuits? If the young person has insurance, did that proposed guardian help them enroll in insurance? If so, that should be stated in the affidavit. If they don't have insurance, when the young person gets sick or needs help, medical attention for any reason, does this proposed guardian support them in any way and help care for them when they're sick? Housing, if the proposed guardian and the young person live together, that can be stated in the affidavit and should be stated in the affidavit, along with any other factors that really demonstrate why this individual would be why it would be in the best interest of the child for this individual to be appointed as their guardian. But again, looking at primarily, education, medical care, housing, and financial support, in addition to like emotional well-being of the child. The affidavit should also, again, list the people that reside in the household, although I don't think that's as needed. Again, that can just go in the first paragraph of the affidavit, and then you get into the relationship with the child, how they know each other, and then how this individual is supporting them in all these different ways. In addition to a little bit of personal history from the proposed guardian. It says here that a statement about their criminal history or lack thereof can be included. I would say that's not necessary for the affidavit itself, unless you're trying to waive fingerprints. Or part of the family court process, some judges will require the proposed guardian and adult household members to get fingerprinted and do a background check. But that's not necessarily actually a requirement, and it can be waived. So if you're trying to get that requirement, or not requirement, that fingerprints waived for the proposed guardian or any adult household members, a statement about criminal history or lack thereof would be good to include in the affidavit. I'll add to that, if the proposed guardian is aware of the special findings, the other special findings factors that need to be included in the special findings order, they should speak to them too. So, for example, if the proposed guardian is a parent, a mom or dad, or even just an uncle or a sibling, and they are aware and had witnessed to some of the abuse or neglect that happened to the young person, they should speak to that in the affidavit. So that's when I said when they mirror each other, the affidavit of the proposed guardian and the child, that's what I'm speaking to, right? And then they can also, if they are aware of why it would be in their best interest to remain in the United States, they should include that at the end, or a statement as to why it's their best interest to remain in the United States. Okay, so the affidavit from the young person is just really telling the child's story. And every single element of SIJS needs to be included in the affidavit for the young person. So that they're unmarried, they're under their age and date of birth, and then perhaps most importantly, why reunification with one or both of their parents is not viable due to abuse, abandonment, or neglect. So statements detailing the abuse that happened or the domestic violence that the child was witness to need to be included in the affidavit to prove why reunification with that parent or both parents is not viable. The best, and then in addition, the best interest prong needs to be detailed in the affidavit as well. So just like a statement about why they should not return to their country of origin. This can look very different and it's super fact specific. If the child did suffer any harm in home country, that can be included there for part of the best interest prong. If they have no viable caretaker in their home country, that should be included because that is a stated reason why it is not in their best interest to return. And a statement about the relationship with the proposed guardian and how that person cares for them and why they want that person to be appointed as their guardian should also be included in their affidavit. So it's hitting every prong and should start with just the first paragraph will kind of mirror the proposed guardian's affidavit, and that it's a statement of who they are, their date of birth, their age, their relationship to the proposed guardian, and that they want them to be appointed as their guardian. And then you can have a paragraph just stating that they are not married or have never been married, and then get into the reunification with the parents and any abuse, neglect, or abandonment that happened by one or both of the parents, and finally the best interest prong, and then the relationship with the proposed guardian and why that individual should be appointed their guardian and how they support that young person. Okay. So those are the two affidavits which during the clinic will be worked on. The point of the affidavits, right, is to get this special findings order from the court. And so, in addition to the guardianship order. So, my understanding is that the special findings order itself is not going to be drafted during the clinic, but just some things to keep in mind because the affidavits are the primary source of evidence to obtain the special findings order. Some things to keep in mind when working on a proposed special findings order are to always include the jurisdictional basis, as well as the purpose of the proceeding, right? So that the purpose of the proceeding is to protect the child from this abuse, abandonment, neglect, right? If you have a case where the child's parent, their birth father, is not listed on the birth certificate, which happens pretty frequently, the special findings order needs to include the name of the putative father in order for it to be granted by USCIS later down the line, for the I-36 to be granted. So part of the affidavit will have to speak to how they know this person is their father, and so that the court can make a finding that that person is the putative father in the special findings order. If the parent's name is not known because of like sexual violence, then that needs to be included and in the special findings order as well, to explain why the parent's name is unknown. for the similar basis prong, if that is what's being argued, a lot of case law really needs to be put in there, and it needs to be explained what the similar basis is to, which in New York State, if it's based on death of a parent, that is abandonment. It's a similar basis to abandonment. So throughout the special findings order, it's really important to include a lot of citations to state law, both statutory and case law, throughout the order in every prong that would require. So the dependency prong, the reunification prong, the best interest prong, all need to include state law citations throughout the special findings order. In the past, when those citations were not included, a lot of requests for evidence or notices of intent to deny the SIJS petition were issued. So it's important to include those. Okay, so as mentioned, I believe at the beginning of this training, on the day of the clinic, the day is going to be split up into two parts. And on the first part of the clinic, the focus is really going to be on the affidavits and drafting the affidavits with both the proposed guardian and the young person. So you're going to get all of the meat of the case during the first half of the clinic. In addition to drafting the notice of motion, which is a pretty simple notice. The second part of the clinic, the second half of the clinic, is going to be focused on filling out the family court forms themselves. So this is the guardianship petition. If I remember correctly, most of the young people, if not all, are over 14. So the form that's going to actually be filled out is the 61A, which is a self-petition. So if a child's over the age of 14, they can self-petition to have for the appointment of a guardian. And that just makes the process, if they end up being represented, cleaner. The form 61 or 61A would be the guardianship petition itself. It's about like a 6 or 7 page form that details information about the proposed guardian, the parents of the young person, and goes through whether there has ever been any child abuse neglect by the proposed guardian, indicated or unfounded reports by ACS, or restraining orders. So it goes through that to make sure that this individual would be a good person to be appointed as a guardian for that specific young person. The form 6.2 and then the form 6.3. These are both just 1-page forms that are fairly simple to fill out. One is going to be signed by the guardian, and the 6.3, and then the other will be signed by the young person. And I'm going to forget which one's which, but one of the forms is a consent to guardianship by the young person, or a preference of guardianship, and then the other is the corollary for the proposed guardian. Okay, so as Marjorie said, there's 3 phases to this process for SIJS. So we've just gone through the whole family court process, right? We've submitted the petition for guardianship, the special findings motion, had testimony in court on all the prongs, in addition to guardianship, and the judge has issued a guardianship order, letters of guardianship, and a special findings order. So now you have the predicate orders, and you can file the I-360 special immigrant juvenile status petition with USCIS, which is step 2. Okay, so when you're filing with USCIS, the child needs to file the I-360 petition, so fill out that form. In addition, if the child's being represented, a notice of appearance by the attorney, and what's going to be attached as evidence to that petition for SIJS are the special findings order that the court issued, the guardianship order or custody order if you did a custody case, letters of guardianship, in addition to proof of age. So the birth certificate with certified English translation needs to be included. If the case was based on death of a parent, the death certificate also needs to be included. It's super important that the petition for SIJ be received by USCIS prior to the child's 21st birthday. If it's not, then they have aged out and they no longer qualify for SIJ and they're out of luck. So it has to be received by USCIS before their 21st birthday. The recent bill that became law, HR 1, made a change, and now there is a filing fee associated with SIJ petitions, which is $200. So that needs to be included in the filing now too. Everything's changing pretty quickly, and filing addresses change regularly without notice. So just always check the USCIS website for a current edition of the form and filing address to make sure that you're filing the correct petition form version, as well as sending it to the correct location, because that does change, and sometimes without notice, more often than one would think. Okay, so you filed the SIJ petition, they received it, you got a receipt notice. USCIS, this is one of the few applications or petitions that have this requirement, but they are required to adjudicate the SIJ petition within 180 days. Any request for evidence or by USCIS will not pause or delay that requirement. So it's 180 days, period, that they are required to adjudicate the petition. So within 6 months, should have a response. Hopefully SIJ is approved and you've completed phase 2. Okay, so phase 3 is applying for adjustment of status with USCIS, or if you're in immigration removal proceedings before the immigration judge. So in order to apply for legal permanent residence or lawful permanent residence, an individual has to be eligible to adjust status, meaning they have to have an approved underlying petition. In this case, the I-360 SIJ petition needs to be approved, and a visa has to be available for them to receive. So how do you know if a visa is available? You need to look at the priority date. The priority date is just the date that you filed the SIJ petition with USCIS and they received it. So that's the young person's priority date. In immigration law, like Congress has allocated a certain number of green cards per category that can be issued each fiscal year. And so because of that, there are a lot of backlogs, and more people have applied for visas than there are available, and that's created backlogs across pretty much every single category that exists. That is true of SIJ as well. So in order to know if there is a visa available, you need to look at the visa bulletin, which is found on the Department of State's website, and look at the EB4 category, which is where SIJ is held for some reason, and see if their priority date is current. It is a long wait right now for SIJ, unfortunately, but once the priority becomes current, then the young person can apply for adjustment of status. To file for adjustment of status, you just need to fill out the I-485, which is the form for adjustment of status, include a notice of appearance if they're being represented, include identity documents, which would be birth certificate, passport, if they have one, an approved I-360. I would say pending. It's way backlogged, so that's not even in the past. You could concurrently file. That's no longer the case. But proof of your approved I-360 with current priority date. And if the child or young person has any arrest history, dispositions need to be included in that filing, in addition to a completed and sealed medical exam. Okay. So if you're filing with USCIS rather than immigration court, I mean, in both instances, actually, the adjudicator should not be questioning the underlying basis of the I-360. So they should not be looking at it, I-360 in reality. They should not question it. The approval notice is sufficient. And they should not be looking into the state court finding. The application for adjustment status should really be focused on, and the adjudicator should be focused on the adjustment status purely, and the fact that they have an ability to do that. So the form itself is what they should be looking at for the adjustment status form. It is. Yeah, I just went over the high demand and limited visa availability. So if you're adjusting in immigration court, similarly, the judge should not be looking at the underlying SIJS, although sometimes they do ask questions to see if SIJS was automatically revoked by statute. But if a child's in removal proceedings, then generally speaking, the immigration judge court will have jurisdiction over the adjustment status application, and that application will need to be filed with the court. However, there's one caveat to that. If the individual was designated an arriving alien, then and they were placed in removal proceedings, USCIS actually has jurisdiction over those applications, not the court, even if they're in removal proceedings. So you can look at the individual's notice to appear to see if they were designated an arriving alien, but that's the caveat. Otherwise, immigration court will have jurisdiction over the adjustment status application if the child's in removal proceedings. So if that's the case, there are two options. You can either move to terminate proceedings so that the child can adjust status with USCIS, and then you just include a copy of the order terminating those proceedings in your adjustment status application with USCIS. Or once the I-360 is approved and there's a priority date, current priority date, the child can file the 485 with the court and have the judge adjudicate the application. That would require a trial. So I would say that USCIS is a more child-friendly way to move forward. However, sometimes the court might be more expedient. So dependent on the judge's docket and availability of their calendar, right? So some things to keep in mind when deciding which whether to pursue the adjustment status in court or out of court. Yeah, and biometrics will need to happen in advance of the interview or hearing for the application to be adjudicated. Okay. So just some recent policy updates. So a few years ago, there was a policy instituted called as a deferred action policy, where individuals who applied for SIJS could be issued deferred action, and then based on that deferred action, they could apply for a work permit while they were waiting and receive a work permit while they were waiting for their priority date to become current, so that they would, have some sense of some stability, right, and weren't just languishing, waiting for their the visa bulletin to advance. So that was a really great thing for SIJS clients. because they were able to work, they were able to get a Social Security card, and while they're waiting for their ability to apply for adjustment status. That policy was recently revoked. In June, USCIS terminated that program. And because of that, they're not issuing approval notices with deferred action anymore, and individuals are not able to apply for a work permit based on a SIJS approval. Instead, they have to wait like the 4 or 5, I forget how long it is now, like 5 or 6 years until they're eligible to adjust status. And when they apply for adjustment of status, they can apply for a work permit. So it's putting these young people in a really difficult position, right? The revocation of this deferred action policy is being litigated in EDNY. The case is ACR v. Gnome. And so I believe they had a preliminary hearing and supplementary briefing already on that case. So that case is still pending, and the revocation of this policy is still being litigated. Okay, I'll pass it back to Sarah.
Thank you, Elizabeth. So before we start wrapping up, I want to also make sure that we go over some very important tips and strategies to understand how to approach trauma-informed client interviewing on the day of the clinic. So I think it helps to have some foundational understanding of trauma and why it's really important to understand how it affects our brains before meeting with clients or before asking them about their past abuse history. So traumatic memories are not remembered in words or thoughts necessarily, but mainly in the reactions that those memories cause to their nervous system. So it could be the image, the sensation, or the emotion. Recalling traumatic memories can cause a client to re-experience those memories, which could trigger some flight, fight, freeze, or fauna reactions. So it could also create some type of disassociation while you're interviewing them on the day of the clinic. So trauma impacts overall how your client perceives and interacts with others, and that does include you. It includes attorneys or advocates who may just be trying to help, but the client's past trauma may not allow them to fully trust or to maybe be fully transparent about what they've been through. Trauma also impacts our clients' ability to communicate. So you'll notice that during the interview, you might ask one question and they might respond to a completely different question. Like they might respond in a way that isn't even relevant to the question you asked, or maybe they're telling their story in a very nonlinear manner, or maybe giving very short answers. And so that could be a trauma effect as well. Also, their decision making is affected by their past traumas, their ability to build trust, as I said, between client and attorney, and their physical and emotional ability to engage in case preparation. So that's something that we are very careful about when we're first interviewing our clients and doing intakes with them. We have to really assess whether they are in a place where they can testify in court and they can handle someone asking them questions about their past abuse in a way that might feel combative to them or might feel disbelieving. So as I said earlier, trauma shows up in what may seem like a confusing response from a client. If it's a nonlinear response, if they can't remember details like names or dates, maybe they can't even remember the year that something happened. That's very, very normal for our clients, because especially if they've had a pattern of abuse throughout their life, certain incidences that may seem like a huge deal to us, of like, oh, how can they forget what year this happened or how old they were when this happened? It's very, very possible, because especially if they went through similar situations and incidences throughout their life, they start to blend in together, and it's very difficult to remember even maybe where they were during a certain incident. Disassociation goes along with the memory impact as well, where clients often act unaffected by horrible stories they're telling you. This is definitely a defense of the brain to separate their emotional response from the details of the actual memory. And then some traumatic triggers. Of course, clients will want to avoid themes or topics of conversations that remind them of their abuse, or even use very vague terms to talk around the abuse. Something really important when that happens, something really important to do is allow the client to maybe take a break, or explain to them why you need that information, that you're not asking just for the sake of asking or out of curiosity. You're asking because this will help their case. And the end goal of drafting these papers is to get them status, and that we just need to understand the abuse they've gone through, so that the judge understands it. Because if the attorneys understand it, we're able to articulate it in their affidavits and in their motion in a way that hopefully will require the least amount of testimony possible when the client appears before the judge. So it's really important to recognize the signs of overwhelm in your client on the day of the clinic. Some signs could include becoming very silent, changing the subject, just not wanting to talk about the case at hand at all, appearing spaced out, or suddenly switching between emotions. Maybe they'll be really frustrated all of a sudden, and then get very happy or very sad. They might talk about the past and present terms as if it is happening now. And of course, if that happens, you have to clarify, is this happening now? Are you still in this situation like this? Can you tell me the date or the season or a possible year, or how old you were when this happened? And even maybe getting agitated or frustrated with the questions. And again, when that happens, definitely good to take a break. There will be food on the day of the clinic, I believe. Maybe take a lunch break. Tell the client to go for a walk and come back, or maybe even change the subject for a bit and talk about something neutral, like, oh, what'd you have for breakfast? How is the weather? Is the weather changing? If the client has kids, maybe asking like, how's your child doing? Are they in school right now? What are your plans for after this clinic? Anything that is neutral and not related to the case. So I also want to make sure we go over some tips for responding to client overwhelm, or to what you suspect may be the client being triggered. So, and this is actually in general, I think, something really important to think about at the beginning of the client when you're first approaching them, and when you're setting up the table for the client to arrive and sit with you. So just think about the physical safety aspect that the client may subconsciously feel. and be mindful of the positioning that you have in the room while sitting next to the client, especially in relationship to the door or having the back to the wall or the proximity to you, making sure that there's a respectful amount of space, not encroaching upon the client's space too much, that the client has a choice as to where to sit. So maybe when the client is approaching on the day of the clinic, everyone's standing up and asking the client, oh, where would you prefer to sit? Maybe allowing them to sit somewhere where they can see the door and they can see the exit. Also the emotional safety aspect, letting clients know that they can stop you anytime and encouraging them to tell you when they feel overwhelmed or need to take a break. That is usually how I open up conversation during client interaction, asking how they're doing, how was their transportation or their commute to the office location, letting them know we're going to try to get this done as seamlessly and quickly as possible so you can go home. Thank you for joining us for the day and taking out your time to sit with us for this. Reminding them that, we are working on your terms. If you need to stop and take a break, you let us know. If you need to go to the bathroom, you let us know. Never feel like you have to just sit here through this, and that you can't tell us what you're thinking or what you're feeling. And then lastly, psychological safety, explaining the reasons behind your line of questioning. I always do that before I ask about past abuse or past trauma. I'll let them know that, I'm really sorry that I have to ask you these questions. And I'm asking just for the sake of your case. Everything that we talk about is privileged and confidential, and I will not tell anyone what you're telling me now. The client, I will be telling all the clients this as well, but remind them that, whatever we write in the affidavit will be read by a judge and will also be seen by their proposed guardian. Just as a reminder to them that, if they're telling us something very personal that they don't feel comfortable with their proposed guardian knowing, then that shouldn't go in the affidavit. Of course, we will need to have at least some information about the abuse, neglect, or abandonment that the client faced, but making sure that you're on the same page and that they are very transparent with you about what they don't want included in the affidavit. And then you also in return being transparent about how it could affect their case if they don't want to include certain incidences that might strengthen their case. All right. Oh, and then I think one thing that I forgot to mention is definitely establishing to the client that when you're asking clarifying questions about something that they went through, establishing with them that you're not asking them because you don't believe them. You're asking them because you want to, these are questions that the judge will have. These are questions that the judge may ask them. And we want to make sure that we are on the front lines for them when we're drafting their affidavits, and that the affidavit is as clear and concise as possible so the judge will have the least amount of questions possible. We don't want the young person to have to explain or testify to, all these horrible incidences in front of the judge. They will have to testify to some, but the least amount of testimony possible is best for the client. All right. So flooding is a term that is used for when someone is experiencing re-traumatization and maybe all this information is flooding back to their mind. All these memories are flooding back, and it feels like information overload for them. So something to bring the frontal lobe of the brain back in line is we have to remind our clients of where they are, keeping them grounded in the here and now and helping them, quote unquote, return to their bodies. And then I know I've mentioned this a couple of times, but again, taking a break from talking about traumatic material, taking a walk, getting some water, asking the client to talk about something positive in their life, even breathing exercises, breathing in for 3, breathing out. And of course, if any of you don't feel comfortable in responding to the client's trauma in that moment or want extra assistance, I will be there, Elizabeth will be there, and Marjorie will be there on the day of the clinic. You can call us in any time throughout the clinic. We are happy to help, and that's why we're there. And we have dealt with a lot of these situations with clients very often. Something that I have done in the past with clients, especially when I'm preparing them for trial or testimony, or having them talk about or recall memories that they haven't talked, that maybe they have never talked about or they haven't talked about in many years, is I tend to do a little stretching session with them. I think that helps a lot as well. And then lastly, reminding the client that you're there for them, that they can trust you, and that you are a friendly face and someone who's just there at the end of the day to make sure that they ultimately reach their goal of getting SIJS status. Okay, I know that was a lot of information we threw at all of you. I wasn't checking the chat for questions, but we have—
I did not see any come in.
Okay, we have about 10 minutes. Very happy to answer any questions.
I did have a question about, in your experience, how do you find the family court judges' receptiveness to understanding like what it means to be interacting with traumatized children and to be asking these hard questions? Do you find that there's like a level of sensitivity and understanding of what might come across as evasive is really just the impact of trauma?
Yeah, I will say generally family court judges are a lot more understanding when children are testifying, and with SIJS cases, I've even had a couple children's appearance waived by judges where I didn't directly or outright ask. I just said, oh, the child has school that day, so I want to make sure, like, can you confirm that you'll be having the child testify if she's going to be taking off for school? And the judge immediately responded that I'll waive their appearance and their testimony. I have heard, thankfully have not had this experience, but I have heard from other folks that some judges are a bit more hostile or just don't understand how SIJS works. But overall, I think they're pretty good. Elizabeth, I don't know if you've had a bad experience. But.
I mean, I'll say it's super judge dependent. There are a few judges and referees that do not believe that it's their job to do SIJS and adjudicate special findings motions, and they are less understanding in those cases. So it is judge dependent, and when litigating one of these cases, it's for that reason important to kind of check in with other practitioners that go to that particular family court frequently and get intel on that judge. I will say that, as Sarah already mentioned, there are quite a few great ones, and you can get testimony waived in a lot of cases, or simply have the proposed guardian testify. And I think family court judges are more receptive to doing that and understanding doing that because they're looking from a child welfare perspective, but that's not true across the board.
It looks like Nori has a question. Nori, I can't hear you at least. If you want to throw it in the chat, I'm happy to read it out loud.
Happy to take any other questions in the meantime while we're waiting for Nori to send her message. And I don't know if we mentioned this earlier, Rebecca, but I believe there will be 2 separate rooms for the guardian and the young people, just so that when you're all interviewing the guardian and the young person, you can do it separately, so that the young person might feel more comfortable if there's something that they want to tell you that they don't want to say in front of the proposed guardian.
Yeah, absolutely. We'll have we have a whole floor of conference rooms reserved, and then also a sort of like gathering room so people can sort of move in and out as needed. And Sarah, if you could just provide me with the names of guardians for security. I know I have the list of the actual clients already.
Yes, definitely.
Fantastic. Nori just messaged, are there any issues around attorney-client privilege that we should be mindful of on the day of the clinic? I suppose the one regarding the guardian is important, but I'll let you explain the thorniness of that, Sarah.
Yes, definitely. So for the purposes of this clinic, your client is the young person, not the proposed guardian. So important to keep in mind that if there is something that the young person has told you that they do not want to tell the guardian, very important not to inform that to the guardian, and be mindful of what you are disclosing to the guardian. Yeah, the guard. It's just in the beginning of the clinic. I would ask the young person, like, is there something in particular that you only want us to know? And then making it clear to the guardian that I do not represent you for purposes of this clinic. I am representing the young person on this day of the clinic in helping them in their SIJS case. And I will also make sure that is clear to them going in, but again, best practice is to remind both of them on the day of.
And we'll have engagement letters, just because we've been, I think some clients, particularly when they see that we're located right above Port Authority, get concerned these days. So we'll have engagement letters that will help to really clarify that we represent the young person for the next couple of weeks and not the guardian. So that should help with that conversation, because I know from some of my own representations that can get a little bit tricky sometimes. Looks like Danielle has a question.
Yes, curious. So, how do any recent policy updates or education trends kind of impact how we like the preparation for the SIJS cases? Or is that more on the purview and you kind of just, it's BAU and you kind of keep going through the same process as you would normally do? Kind of curious to see if there's any impacts there.
Elizabeth, can I have you take this one?
Yeah, sure. So I think there's 2 things. One is in terms of preparing the case, I think a lot more people in households and proposed guardians might feel more reticent to share certain information like address history, or even go and get their fingerprints taken in court. And so that is part of like the conversation that you have to have with the proposed guardian and the client, just because of all the enforcement actions that are happening across the country, right? So that, I think that conversation is, while was prevalent in the past, is just much more frequent right now. So kind of explaining to the family or the proposed guardian and the client what protections we have in New York State, New York City, what motions we can make to help them feel more protected in the family court process. That's one factor. In terms of actual preparation of the petition and the special findings motion, I think this was true in the past, but I think it's more true now. Just paying particular attention to what goes into special findings order and making it more including a lot of case law is important. So like in the past, you would see special findings orders that were a bit more bare bones, that just had a few facts that were not very detailed as to what the reunification, like the non-viability reunification was about. That cannot be the case in special findings orders now, because they will get denied. So just ensuring that the special findings order, or the proposed one that is submitted to the judge, is detailed and includes a lot of state law, both case law and statutory, is important. Some adjudicatory, this happened in the past Trump administration, and I haven't seen it happen yet, but I presume it might happen again, is that SIJS denials can happen if there isn't a sufficient amount of citation to statute specifically, in addition to case law. But you need to have both in there throughout the order and be cognizant of that. Additionally, I spoke about this in my section, but including the parent's name, if they're not on the birth certificate, is essential because it will get denied if it is not included. So, I mean, to answer your question, the general process is not that different. However, you just need to do a lot more cross-referencing across applications. If there are any other applications that are pending that the child has submitted, then it's really important to cross-reference those when you're drafting the proposed special findings order, to both see if you can support that other application and make it stronger if you want to, and two, just make sure there's no contradictory information across either application. Other things to keep in mind are the terrorism bars that exist in immigration law, and the fact that a lot of gangs have been recently labeled as terrorist organizations or designated as terrorist organizations. And so not including information about like extortion by us, like not including the specific gang, might behoove the client, right? In the special findings order itself, right? Because we don't know if other terrorist organizations are going to get designated in the future, like, that are just, gangs. So it is important to just like keep all of those overlapping issues in mind when drafting the orders and the petitions, because down the line it will have an impact on the adjudication, whether it be at the I-360 stage or at the adjustment of status phase. And if an I-360 is denied and the person is not in removal proceedings, there is a memo in place now that states that USCIS should issue a notice to appear and place that individual in removal proceedings. So for those reasons, it's important to kind of just make sure that the application is strong, and then look at any negative factors that, or potential negative factors that could pop up, and think about whether you want to include certain facts or not in the special findings order itself.
Thank you. Very, very helpful and informative.
If there are no other questions, I will provide that very important information, the CLE code. It's 1088. Again, that's 1088, and there's a link in the event invitation that you can fill out, and we'll process those credits for everybody. Well, Sarah and Renee, I know we'll talk over the next few weeks about some timing logistics and things like that. But really looking forward to having everybody here in a few weeks and putting all of this training into action. And thanks to the team from fast moving area right now, and really appreciate you guys getting us up to speed.
Yeah, thank you, Rebecca, for including us again, and we look forward to working with both you guys and the sanctuary team. Thank you, guys.
Yeah, looking forward to it. Thank you, Rebecca. Thank you, Renee.
Have a great afternoon, everyone.
Take care.